Welcome to All Things Policy, a daily podcast supported by Pragati, a flagship media initiative of the Takshashila Institution. We're a bunch of policy nerds based in Bengaluru, and we like to bring a fresh perspective to Indian affairs and an Indian perspective to global affairs. So grab a cup of coffee, sit back, and join us for today's chat.
Hello and welcome to All Things Policy. I'm your host, Shrikrishna Upadhyaya, and my guest today is Satya Sahu, my colleague and a researcher with the High-Tech Geopolitics program at Takshashila. Satya is also a lawyer by profession. Satya, welcome to All Things Policy.
Hi, great to be here, Shri.
So today, Satya and I are going to be talking about the India Justice Report 2022, which released earlier this month. And the India Justice Report is a first of its kind national periodic reporting that ranks Indian states and union territories on their capacity to deliver justice. The report broadly studies 4 pillars of administration of justice, being the police, the judiciary, the prisons, and finally the legal aid. Today in our conversation, Satya and I are going to be focusing on the judiciary angle from the report. The report is full of very interesting statistics, but I'm going to lay out a few glaring points so that we can set the context for this conversation. The first point which I want to bring forth is, when we talk about judiciary, of course, all of us have our pet peeves that judiciary is not functioning as well as it is supposed to. But the fact is, no court in India today is working with a full complement of judges, except the High Court of Sikkim and the district courts in Chandigarh. So every court in the country has vacancy at some level. And in high courts, this vacancy is up to 30% on an average, while in district courts, this is somewhere around 25%. When we talk about case clearance rate, among the 18 large and mid-sized states in the country, only Kerala could achieve 100% clearance rate, and no other state has been able to do this. When we talk of the composition, the social composition of the judiciary, at the district court level, no state or union territory has been able to fully meet its SC, ST and OBC quotas. And of course, such reservations do not apply to the higher judiciary, and the report does not have these numbers as well. The other thing that I think it is pertinent to mention is, what is the number of judges per million population in the country, and how does this fare against the recommended number? So we do not have a very latest recommended number of judges. We have to go back to this Law Commission report in 1987, which said that India should look to have 50 judges per million population in the next 10 years, starting from 1987. But where are we today? 14 judges per million population on an average. And this is just horrible. There's no other way to say it. And when we talk of criminal justice system in the country, or just administration of justice in the country, the fact that our judiciary has so many vacancies, has such high clearance rates, the fact that we don't have enough number of judges per population, plays a major role in hindering the administration of justice. So Satya, I would like to bring you in at this point, and I want to know from you, so what are your top level takes went through the report, and what do you think are the consequences of this stifling amount of vacancies that exist in the judiciary today?
Shri. So the issue with vacancies and the shortfall existing in the judiciary is also inextricably linked to shortfalls and vacancies in the police force. So some of the statistics that stood out to me, fact that the average vacancy at the officer level in the police force is 28.6%. Now keep in mind that this is not simply an absolute number. A lot of states have usually also lowered the sanction strength of police personnel just to show an improvement in the total number of police personnel in the state has increased over the years. Right, so this may actually be even worse in reality. So what this does is it impinges on the investigative capacity of the police for anything related to petty theft all the way up to actual civil case enforcement as well. And also the supervision of a very large constabulary. This has been pointed out in the report, but most people do not actually know about the fact that a single police station in rural areas may actually be covering huge swaths of areas and a very, very scattered population. This will figure out in a point that I'll bring up later down the line in this podcast as well. Okay, the next thing that we're going to talk about is the training budgets and allocation. Nationally speaking, it's the average amount of money spent per police personnel per year is only 9,000 rupees. Now, this becomes even worse when you're thinking about the fact that a lot of this expenditure is actually concentrated in urban areas, either tier 1 or tier 2 cities, and even then in very specific areas or sections of the police force. Maybe it's in terms of CCTV surveillance measures instead of actually training investigative level officers in constitutional ethics or human rights, which are the need of the day, to be honest. Alongside that, the police personnel per training institute is also woefully low. So what this means is the training institutes are deprived of resources due to mismanaged funds or centralized planning, and also they're overloaded with work alongside the meager resources. Okay, now let's talk about how the judiciary, the lower judiciary, comes into focus when you're talking about the shortfall in policing capacity. So 69% of the pending cases out of 4.9 crore, these are cases that have been pending before the subordinate courts as well as the high courts for more than 5 years, right? The 69% of those are criminal cases. In my experience, having interned at multiple criminal lawyer forums, a lot of these cases are very solitary in nature or very petty in nature. So it can either just be theft, or it can simply be a random disagreement, a small brawl in the street. It can also be something as problematic as domestic violence, right? So the thing is, the usual modus operandi that has evolved over time in India is that because the process is the punishment, a lot
Yeah.
of these criminal cases are essentially just people going to the police, filing an FIR for malicious reasons or for genuine good faith reasons, and the police is going to throw every single section that they can think about on the wall, see what sticks, and then proceed with that. So usually what happens is if there are two people involved in a petty theft case, the police is going to immediately invoke criminal conspiracy, which is an offense that is on a very completely different level compared to a case of petty theft. So a case of petty theft can go to the Lok Adalat. A case of criminal conspiracy cannot, right? So stuff like that. So when you have criminal cases of this nature, the impact of this will become more evident when I discuss the second order effects later down the line. But think about it, this is the kind of criminal cases that usually fill up the caseload of subordinate courts and a lot of the high courts as well. Right. So now let's take a look at the numbers for high court vacancies. The national average is 30%, which is extremely problematic considering the fact that the high courts are usually where a lot of appeals just die out, or where a lot of writs also just die out. And given the sorry state of justice dispensation in the country, the writs and the ordinary power of the high courts are extensively used. Right. So if there are 30% vacancies across the nation, then you'll have a problem figuring out which cases will go to which roster, which makes the impartiality of a bench hearing a case some circumspect. But let's not go into that. In the district courts, the shortfall is a little bit better, but not much. It's 21.7%. As opposed to police personnel, sanction strength of courts generally are not amenable to doctoring. So that's at least that. Also keep in mind that both police personnel shortfalls as well as judiciary shortfalls, they're all chronic in nature. That means they've been continuing for decades on end, which also means that the pendency of cases as well as the quality of the justice dispensation grows progressively worse over time. It's creating a self-perpetuating loop that is very difficult to break. It's very difficult to disrupt. When you have overworked judges in the subordinate courts, I actually have a study by Jason West, PhD in economics, writing for the University of Houston. He's talking about vacancy in justice. This is analyzing the impact of overburdened judges on sentencing decisions. Right. So this is a US-based study, but I think the lessons here are globally adaptable as long as you're following a rule of law and have a separate judiciary and executive, all of that. So I'll just quote verbatim the results of the study, and they've used a fairly detailed multivariate testing analysis framework as well. In general, our results support our hypothesis that vacancies affect the severity of punishment as measured by downward departures and sentence length. Vacancies also affect the distribution of sentences, causing judges to cluster their sentences at the minimum guideline. So what this means is essentially if offense prescribes, the minimum sentence for XYZ is 7 years. That does not necessarily mean that, the judge is constrained to use that as a sentencing guideline. But an overworked judge will just sentence the accused to 7 years and then be done with it. They'll not apply their minds further to either, lessen the sentence based on extrinsic factors or maybe appreciate it. We don't know that yet.
Thank you for listening to All Things Policy. We'll be right back after a short break. So I wanted to jump in here because you made a lot of interesting points, and especially the interconnection between the police system and how us lower courts or the subordinate judiciary functions in the country, right? And one thing which stood out for me was when, I mean, this was a common knowledge, but when you put it in numbers, it's scary because it says nearly two-thirds of prisoners in the country are under trials, and the prisons are overburdened by up to 130%, which means, where 100 persons could be put in a prison, there are around 130 people on an average. And this is scary because, there exists so many provisions in law which say that a person cannot be kept in jail. The bail is the rule. And of course, if some person has spent up to half of the total prescribed punishment for the offense in which he has been charged under, then he cannot be kept as an under trial anymore. He has to be released forthwith. But this simply does not happen. And I was talking to a friend who works in this sector actually. And what she told me was shocking because, one of the reasons prisons are not able to set free under trials is simply because they don't have records as to how much time a
Yeah.
particular prisoner has spent in a prison. In the sense, they don't have proper digitized records which can be accessed immediately. They have to open a big ledger, they have to go through multiple pages, they have to find out this person's name, what is the section he's been charged under, what is the maximum punishment. I mean, none of this is automated, and this itself is one of the reason why, even a prison official is not able to release an under trial on time. But having said that, just to sort of zoom out a little bit, right? And I think, yeah, before I do that, one more thing, which is like you mentioned about minimum sentencing guidelines. I think one thing which plays out in a similar way in a different context is when sending somebody to judicial remand or custodial remand, right? A
Exactly. Yeah.
magistrate is supposed to apply their mind to a particular case and decide whether, custodial remand or judicial remand has to be given, or this person has to be set free on bail. But in India, it's almost seems like an automatic procedure where, you're produced before the magistrate after your arrest, and the magistrate simply sends you to a jail. And there is, at that level, there is no application of mind as such. It's almost mechanical. And one of the reasons is that, they're simply overworked. There is not enough time for a particular magistrate to make a judicious decision, right? And like I said, I wanted to zoom out a bit and look at the importance of administration of justice, particularly criminal justice in the country, mainly because we are a democratic country and we are supposed to be governed by rule of law. And if you need to uphold rule of law, you need these pillars of judiciary and police which support and uphold the rule of law. And this in turn is much more important to build a politically stable country, to build a stable economy, to build a prosperous nation. And no country has gotten there without, getting these basics right. But in India, we seem to be struggling, and we seem to be struggling for long. So I want to ask you a broad question. So based on whatever we discussed today, the problems of infrastructural constraint, the vacancies, the disregard for rule of law, what do you think are some of the second order effects which emerge from this sort of a situation that we have in our country today?
Right. So this is where the point I made earlier about the inextricable link between policing capacity and the lower judiciary comes into being. Right. So in India, the tendency is for anyone to opt for informal disputed redressal systems. Now, what that means is, in a civil case, it's perfectly fine. Even in a constitutional case, depending on the degree, it's perfectly fine. But in the criminal law, the offense has been committed against society at large, not just a person. So what ends up happening, as you can see, I'll give you an example down the line, is that courts, because they're overworked, would want the parties to a particular case to settle things between them and dismiss the case or acquit the accused. Similarly, the police, and especially in rural areas, what they're going to do is they will try to become the mediator in let's say marital disputes or property disputes in a family, instead of actually taking through the formal process, all of that. Maybe there is merit to that. The fact that smaller cases which are not significant, which are not harming society at large, should be dealt with this way, maybe by a class of personnel, police, that is trained to do this. There's certainly a case to be made for that, because the entire realm of compoundable offences in the CRPC exists for something like that. Then the Lok Adalats, all of that stuff. The problem arises when you have the police and the judiciary willingly and in fact promoting the use of informal dispute redressal system in a criminal process, which is meant to not just redress an individual but also the society at large, and send a symbolic message out that, hey, this kind of behavior is something we do not prescribe. In that case, what happens is it is going to impact legal strategy. So this is what a lot of people confuse domestic violence laws for. Section 498A, that has been instituted to combat marital violence and domestic disputes. Essentially, it was passed of the dowry deaths of 1980s. So the parliament came together, created a provision in the IPC to the Indian Penal Code to criminalize cruelty in marriage. Now, a lot of people criticizing it, saying that it's very broad and the police's powers to arrest is very unrestrained. Now, there have been many legal developments since then which have restrained that, but that's not the point. The point is, because it's so prone to abuse, right? It's very easy to abuse that provision. What happens is the legal strategy becomes, so a victim goes to a lawyer. The lawyer says, hey, the criminal process to get to the logical conclusion of this all, going through the different appeals process from the very smallest session court up to Supreme Court, you're going to end up with a pittance at the end of the day. Nothing's going to happen. Maybe your husband or whoever has abused you is going to get a going to get a sentence of a few years. I don't know. But if you club your complaint alongside other complaints that make out battery, like make out a lot more, like maybe fraudulent, maybe not so fraudulent, but essentially not something that's made out by the facts of the case, multiple provisions, multiple sections, and then you can use the provisions, powers that are given to the police to arrest and essentially use that to extort. Well, extort is not the right word. It's unfortunately the only recourse available to the survivor there, to essentially get some sort of financial security at the end of it, because they're not worried about what the society is going to benefit from this. They're worried about the fact that they need to survive, they need to be safe, they need to have some sort of financial security for themselves or for the children in that marriage. And that is what they're worried about. And the second order effect of that becomes that, people who are about to file bogus domestic violence complaints, they are taking use of this as well. And this is specifically because, by the way, this is a non-compoundable offense. There is nothing in the Constitution or the IPC or CRPC that allows high courts or courts to do this. High courts can potentially do this under the ordinary power they have under Section 482, but they usually restrain themselves from doing that. So the second order, if it is, you are essentially bypassing the legal system, the legal framework that you've envisaged for something like this completely, and that is leading to a lot of unintended consequences, which again are very difficult to, once they've become the part of the psyche of the legal community and part of legal strategies everywhere, it's very difficult to change that.
Yeah, precisely. And just to add a bit more of context here, the thing is, most lawyers are interested in getting an immediate gain to their client, and they
Yep.
are not willing to go through the entire process as well. And sometimes it may not be in the interest of the client itself to sort of go through the entire rigmarole of the criminal justice process. So such shortcuts become inevitable. But in the sense, this is not exactly a people problem. This is a structure and designs problem, right? Because the system is such that it has given all sorts of perverse incentives for the players to manipulate it. And one of the fundamentals of any working criminal justice system should be, judicious prosecution for malicious prosecution. In case somebody tries to file a false complaint against you, you should be able to get that kicked out of the court and also sue this other person and get some sort of justice out of it. But something like that, I personally have not seen happen much in our country because, mostly the processes are being abused. So most people are not willing to put themselves through the process again in order to secure justice. In fact, the state also doesn't seem to respect individual rights. For example, if someone has been illegally arrested or detained or has been made to go through a long process of trial in which there was not even a shred of evidence against that person, there is no role of compensation, there is no role of civil damages that can be claimed against the state. So in essence, what we have is even the players who are willing to abuse the system, there is no accountability mechanism against them. And even this, I think, goes ahead and applies to simple things like perjury, right? I mean, in a better, more functional judicial system, perjury would be seen as crime and it would be punished and immediately punished. But in the kind of system that we have developed, lying as a witness, witnesses turning hostile, these are like very regular instances. And these are again a result of a weak system where the incentives are such that you can get away with it. You can get away with perjury, you can get away with malicious prosecution. So having discussed a bit about this, I wanted to take the conversation forward towards, police training, which I think you had mentioned a bit at the beginning. And one of the things that I heard from Mr. Javed Ahmed, who is a senior scholar at Takshashila, and he's served as the DGP of a state before, and he said that, once a person has been appointed as a constable, they usually have a service of around 30 to 35 years. And there are not more than like 3 or 4 instances in their entire service that they go through some sort of in-service training where they go through education in their particular role, which will help them perform their duties better. It's just that, once you make it, you're there for your life, and there are not many incentives within the system to make them improve their skills or make them opt for training courses, so on and so forth, so that they can perform their functions better. And do you somehow think this is also a result of the kind of weak system that we have today?
I think this is a result of A. So the statistic that is in question here is the fact that only of the entire budget allocated to the police force on the national average, only 1.3% is sanctioned for training, and out of that, only like around a total of 1.1% is actually utilized, which is again a pitiable amount. I think the main problem is the centrality in planning of disbursal of these funds, and the fact that the police structure is inherently colonial in nature. It is meant to be a top-down structure by design, and it hasn't undergone significant reforms to make it more decentralized. If you look at other countries, other jurisdictions, let's look at UK for instance. They can implement mechanisms like community policing. Again, the efficacy of that policing system is something we can't discuss right now, but they can implement mechanisms like this because the control of the police system has been devolved to the local government there. It's under the city's control. Right? It can be escalated to the Home Ministry and all of that stuff. But the general control of the police force, the control of funding, training is controlled by the local government. So, which means that the government is very susceptible to demands or protests by the people who are being policed. Right. So, if they say, "Oh, this guy is not this police personnel in this particular locality," do not know that this borough is populated mostly by senior citizens, and they are making unfortunate calls at night, etc. All of that stuff. So even if their intention is benign, they don't know how to actually police. So train them. So the government can actually disburse funds to train that particular section of the police. Even though that's the case, the political will to reform the police is not going to come from anywhere. Like, because the people who are being policed are unable to reach the representatives and in timely manner have any sort of training or reform being actuated. So I think that is a problem. The way to reform it is very difficult. I would say it essentially means it cannot be a piecemeal approach. It's, in my opinion, because way too many parts of the system rely on each other to function appropriately. So either a dismantling.
No, what you were saying actually sort of reminded me of this discussion we have had once before at Takshashila, which is that, why are basic things in a democracy such as functioning judicial system and good policing system, why are these not the demands of the public in the country, right? I mean, of course, we can go at length about judicial reforms, police reforms, and all of these are very important things, but there is enough thought, there is enough literature on it, and a lot of people, a lot of thinkers have gone through it. Even courts have made a lot of, I think Prakash Singh judgment from Supreme Court came way back in 2007 or 2008, and which said that, like you mentioned, the colonial structure of this police has to be overhauled, and we should bring in new model police laws in every state. But most states have not complied with it. And the problem really is this, in India's democratic system, there is not enough demand for these services. And when voters don't demand this, it is unlikely that the politicians are going to invest much in solving this problem. And like you said, one of the ways in which we could achieve this is by localizing and decentralizing policing, especially in urban areas, because I feel like the citizens here are far more engaging. In the sense that you already told me that, there is more policing in urban areas as opposed to rural areas. So why are urban citizens not demanding better from their police, right? And of course, urban citizens are also governed by municipal corporations, which have nothing to do with the police, because this police comes completely under the control of the state government. So maybe an indirect way of thinking of police reforms will be through thinking about whether we can actually decentralize policing functions, and to what extent can we make funding police systems also contingent upon that kind of decentralization. So that was the thought that I had in my mind.
So this also takes into account that you have to reform and revamp the taxation system, the redistribution of tax revenue across states, local governments, and the center. And that is easier said than done. That's again, which is why, in my opinion, it can never be a piecemeal approach that's going to be able to solve this. It all has to be dismantling of the older system. And coming back to the narrative part, I believe the general Indian public's idea about the police and judiciary is that these are professions that are essentially useless in the way they function, but they also carry a certain status or a prestige associated with them. So people will be differential towards personnel from these services, but will also just dismiss the system as not working at all, or working for the interests of a few, classes in society. No, which is true. The problem is creating a narrative that is going to allow them to demand for, which is going to make them demand for reform in these areas, is just, it has to be a grassroots approach. But again, I don't know, like education and more civic participation may be the answer to it. But again, way too many moving parts are inextricably linked here. There is local government politics, there's state government politics, obviously union level as well. Then you have entrenched cadre. So the IPS officers would not want to revamp. Well, they are afforded a certain status, right? They wouldn't want that to be taken away. Then state level police services. Then you have state level judiciary services. So there's the entrenched interest of cadres in the bureaucratic system and the judiciary system. They're also opposite. I mean, they already do in terms of transfers, in terms of expansion of cadres. They already do that in terms of appointment and everything. So they want to oppose any sort of revamp as well. So I think we should really talk about it in a sense where maybe technology comes as a force multiplier. I'm not sure. Maybe like essentially the police personnel in rural areas, or in, let's say, urban areas which are scantily like tier 2 or tier 3 cities, maybe have technology be a force multiplier. Maybe discussing that might help, might kickstart the demand for reformation. So,
Yeah. Anyway, when you said that, most people perceive our profession as respectable but inherently useless. I think that was a scathing indictment of the profession both of us belong to.
Yeah. We are in policy at the end of the day.
Ex-profession, right. So anyway, thanks a lot for joining me on this chat, Satya. And I hope our listeners have some takeaways from this. And I really hope the impulse of the nation shifts towards demanding more of these basic services out of our elected representatives. Thank you once again for joining me on this chat.
Yeah, it was great to be here.
If you liked our show, don't forget to check out other interesting podcasts on the IVM network. You can tune into them on the IVM Podcast app, ivmpodcast.com, or wherever you listen to your podcasts. You can also follow IVM on social media. The handle is @IVM Podcasts on Twitter, Facebook, and Instagram. And hey, if you'd like to dive into Takshashila's research on technology, strategy, and economic affairs, check us out at our Twitter handle @TakshashilaINST or our website takshashila.org.in.